Hi, my name is Samantha Payne, and this is my presentation for Module 12 on tort law. So, what exactly is a tort? And this is something that I was pretty unfamiliar with going into this project. And it's a civil wrong committed by somebody against another person that caused some sort of an injury. This is probably one of the top things that subject teachers to some sort of personal liability. And you'll see in my cases that I'm about to present that there's always seems to be well intent, but something happens and there's some foreseeable stuff that should have prevented that instance from happening. So there are two categories. There's intentional tort, which means that the person intentionally meant to cause harm. This is something like battery, false imprisonment, those sorts of things. Negligence is something where there wasn't an intent there, but because of a breach of duty or failure to properly observe, something did happen, causing injury. So the first case that I want to talk about today is Mitchell versus Cedar Rapids Community School District, and this was decided in 2013 but occurred in I think 2007 or 8. So a special education student skipped class. She called her mom and said, "I'm going to go ride with a friend on the bus and go to her house." And the mom thought that was odd because that had never happened before, but said, "Yeah, that's fine, go ahead." And so the students skipped their last hour of the day to go meet up with the boyfriend, who was also a student in the school but was older. There was a 4-year age gap, and so there was some back and forth. The girls got a ride with another student, a former student from the school, to another house that wasn't the original place they were going to go. The boyfriend took the girl to a garage and raped her while his friend shot BBs at her. Really weird, kind of a different situation there. And the only reason the mom knew that the students had skipped school was because the student that had given them the ride in the first place called the mom and said, "Hey, so-and-so left her backpack in my car." And so that's when the mom promptly figured out where she was, picked her up, and took her home. And the daughter didn't actually admit to her mom what all happened until months later. And so the mom sued for negligence, stating that the school did not adequately supervise her special education student, nor did they notify her of the unauthorized absence from school in a timely manner. The school had a system set up that any unverified absences there was an automatic call that was placed in the evening at the end of the day. And the mother actually won for damages, and I believe the court decided it was 70% fault to the school and 30% fault to the daughter. And so what USD 457 may have done, reactive, so something to react to that case, they probably would have looked at the student's history. They provided a lot of documentation about what the teachers that were involved in those classes that the students skipped, what they saw. They saw friendly interactions between the student and the two students, the male and the female. And the male actually was, he admitted to third-degree rape in the fallout of this. And then provide documentation to show best efforts in this situation. So the proactive approach would be to have an immediate alert system, which the high school does as soon as a teacher marks a student absent and saves their attendance, and a call is placed on behalf of the school. And then conversations with the students regarding laws that are related to sex with a minor and the kind of stipulations that go with that. As far as the professional ethics involved here, so we have a duty to report those unverified absences in a timely manner. In this case, this teacher did not report or call the parent right away as soon as she saw that the student was missing, because she knew that the school had a system involved, and that kind of, I think, freed her from a little bit of liability, but not the school. In this case, Brachek versus Millard School District, 1979. It's an older case, but I feel like it was still kind of relevant in this situation. So a student was struck in the head with a golf club during gym class by another student, and he was subsequently killed. There were 58 students present practicing their golf swings in a gymnasium, and only 2 teachers, where one of those teachers was a student teacher. And the student who was killed was not present on the day of the safety was discussed, much like in shop class when it's safety day, you have to be there, you need to be there to understand what's going on. The student was not present for that, and nor was he retaught or told the rules from that day. The teacher did not follow written protocol, so there was actually protocol written up that said this is what you need to do when golf is involved in the gymnasium. And he was sued. The school was sued for negligence, and the case was won by the defendant. So the reactive here, what would have happened was probably interviews with all involved to get an entire story, and working with legal counsel to prepare for the impending trial, because it's just one of those things that, yeah, that's going to happen. A student was killed in their care. So what we could have done in this situation to better prepare or not to reduce the foreseeable risk. Fewer students, for sure. 58 students in a gym that's a lot of kids, and especially if they're swinging golf clubs. More supervision. 2 teachers is not enough of a good enough ratio, and maybe in this time it was, but I know today that probably would not have worked. Review proper protocol for teaching golf in PE and follow that protocol. So the teacher thought that they were following protocol, but the written handbook, they were not. So as teachers, we have a duty to protect the safety of our students, and it could be deemed, it was foreseeable that many students swinging clubs in that small space, an injury was due to happen. Brewington versus the Philadelphia School District in 2015. So a 9-year-old was playing in PE again, and ran into a wall uncovered by padding and received a concussion. He missed the end of his school year and then subsequently had issues with memory, and his grades dropped the following year. So the mother sued, and one of the things she cited was control of real property. And the district was found negligent in this situation. And so I thought this was an interesting quote because it does spark some sort of discussion here. So it says, "We are disappointed in the ruling, and we believe it greatly expands the liability exposure of public political subdivisions." So gyms are a tough space as far as covering padding walls. I know that our gym itself has some walls that are uncovered, and something like this could happen very easily. The main areas, the ends of the gym, are covered with padding, and so that seems to be the standard of what happens in gyms, because you got bleachers and all that, and you can't really cover every square inch of the district or of the building. So reactive, probably interviews involved to get the entire story, the teacher, other students, that sort of thing, and then working with legal counsel again to prepare for impending trial. The proactive approach here, work with appropriate officials just to ensure and receive documentation to prevent, a case like this to come through, that all areas of the schools meet the safety standards put forth by the state or the federal government. And create some sort of a PE safety guideline document that teachers educate the students on before beginning each semester. So here's what to do in these types of situations. Similar, again, like I said, to a shop class having their safety standards. A PE class needs it too. I believe a lot of the cases I found were related to PE and injuries happening there. And it's just a matter of having some sort of set guidelines to help protect the teacher and the school. And so my professional ethics, we have a duty to create a safe place for all to learn, and we have to meet code and federal requirements in all spaces. And so I think it was important to note that I think that if the school had met code, if there is some sort of code there with having students in that space, that would have protected them from this suit. So Hoyam versus Manhattan Beach City School District, and this is another older case, but I thought it was still relevant. So Michael Hoyam was 10 years old, who is 10 years old, or was at the time, left school grounds without permission during summer school, and he was standing at a busy intersection. He was hit by a motorcycle and seriously injured. And the mother sued. And this wording was a little bit tough for me, and I did all the researching on it. So ultimately, respondents demurs for failure to state a cause of action were sustained without leave to amend. As to each of these alleged causes of action, this appeal is from the order dismissing the actions against the respondents. So I phoned a friend to help me, who is a lawyer, to help me with this wording, and she responded with, respondents objected and they won that objection. So the original order dismissed the claim against the respondents, and on appeal, respondents are objecting the plaintiffs didn't state a claim, she thinks. That was really tough wording for me to get through, and the result of the case was hard to decide what happened there. Regardless, I think reaction, we would have reviewed camera footage of that student leaving if this case would have happened in 2019. Calls to the appropriate authorities and legal counsel. Proactive, a student that young should not be skipping class. At the high school, it does happen quite often. Students leave, but like I said, we have an immediate alert system as soon as the absence is put in as unverified. But a 10-year-old should have a little bit more supervision in this case. So as soon as the student was missing, didn't show up after lunch or whatever the case may be, call the mother, appropriate authorities, whoever, because he is so young. Or check with the front office. Hey, did Michael get called out of class today? Professional ethics, we have a duty to act as the parents when the students are in our care, and this includes being aware of their whereabouts at all times. Okay, so Barnett versus Caldwell. So a teacher left the students unsupervised to use the restroom, asking another teacher to listen out. There was a hall monitor there, but that she did not ask the hall monitor to step into her class and help her out. 2 students were engaging in horseplay. 1 student, Antoine Williams, fell with another student on top of them, dislocating her collarbone and lacerating a major blood vessel, which ultimately killed her. The court, in this instance, ruled in favor of the teacher, citing her absence as discretionary act that entitled her to official immunity from the duty to supervise students in the classroom. So I thought that was a very interesting ruling, and considering the fact that it was a more recent case, especially because the teacher did leave the student unsupervised, and so the language in the handbook said that the teachers may never leave their students unsupervised, but didn't define supervision. And so I'm wondering if it didn't lay this out exactly in the article, so I'm speculating, but I wonder if because she told another teacher to listen out, that was her version of supervision, and because there wasn't like a direct, you must have eyes on your students at all times type wording in the handbook, that's how the case was won by the school district and not by the individual. So interviewing students in the classroom, the teachers involved, and the hall monitor who was mentioned in the case documents. To be proactive, instruct teachers of their duties and never leave students unsupervised, and define what unsupervised truly means. Professional ethics, we must never leave our classroom unsupervised. That's just, to me, a standard, and the wording, regardless of what the wording supervision is supposed to mean. So here are my references. I'm going to also list my references in the box above my submission, just so that you have that as well. I apologize that my camera and my sound is off. It's bugging me too, and I don't know how to fix it. I'm on my school laptop. I think the only fix would be to get an actual microphone. I believe that's how I fixed it earlier, which is in the building that I don't have access to at the moment. So I hope this presentation was informational for you and you got to see some different cases than you usually see. I tried my best to find new things, not just the first 5 off Google. It was really hard for me to find some intentional tort cases in schools, and I do believe that the majority of the time negligence is what's cited in a tort case in schools, because teachers, we mean well, and kids are kids, and that's kind of the mindset we can have sometimes, but that does leave us very liable to some very scary cases that could happen and things that could happen in our schools and under our care as teachers. Have a great day.